Tom and Roger on. For those of you who don't know Tom and Roger, they're both attorneys. They're both trusted vendors of Buyers Club. And they both have different legal perspectives. So we're going to spend today really spending the bulk of our time just kind of discussing HOAs and what rights they have to not allow rentals in certain subdivisions. So I know some people have been coming up to us and saying, hey, I've had a rental in this subdivision for years. We just got a notice from the HOA saying they're banning them. What rights do we have? Can they really do this? Stuff like that. So we're going to have Tom and Roger just speak on that today. We'll have plenty of time for questions. And if we get through all the HOA discussions and there's still extra time and you have other legal questions for Tom and Roger, we can always cover those too. So we are just going to go ahead and get started.
Do we have an audience? I mean, how many people are on the call right now?
Says 30.
How many?
30.
30. Oh, okay. I can't see all that for some reason, but yeah. Okay. No, great. Great. Oh yeah, here we go. If I click on this little arrows here, yeah, I see. Cool.
So Roger, do you want to talk about, since you had looked it up?
Yeah,
the outright ban issue. Do you want to talk about that a bit?
Well, I can jump in on what the basics, which would focus mainly on that, although it'll spill over.
Sure.
And then I should say also to Suzanne that I at least thought that once we got through the HOA, we'll talk about it as long as people have questions. But I didn't, by no means, Tom does lots of other things within the law, and so do I.
Yep.
So we're happy to answer, investors' questions generally. This is definitely narrowed to real estate investors, and what kind of questions they have.
Yeah.
But we'll start with the HOA issue. We'll see how far it takes us.
Roger, before I get started, I forgot to ask, does anyone on this call currently have one of those houses that this is an issue for? Corey, you do? Anyone else?
Okay.
I feel like, Roger, it might be helpful maybe and Shane, it might be helpful for maybe Corey, if you have a second, or Shane, to just kind of share a little bit about what's happened, just so people kind of have a little bit of a background update, and then help lead into you kind of responding to them. So I'll have Corey, maybe you get it started, and then Shane and John, if you have anything else to add about your stories, kind of go from there.
Can you hear me?
Yep.
Yep, we hear you.
All right. I believe Brian and Tom both have the document that I was sent, but this has actually been going on since I've owned the property in 2020. I've been getting notices every year that they're trying to vote or having a vote to basically ban rentals outright. So every time that's came up, I voted not to allow the ban. But this year, I got a notice saying that the ban had been passed and that I have until the end of the year to basically vacate the property of tenants, and then otherwise I face, fines. I can't remember what the exact wording says, but Tom has that copy because I actually sent that to him right after I got it, and I just sent it to Brian recently too. But that's kind of the gist of the story.
Okay.
Shane, is your story similar? Oh.
We can't hear you, Shane.
Yeah, I'm sorry. I apologize. I'm driving. I'm trying to figure it out. I have my phone mounted. Yeah, we got to.
Oops, you cut out again. We heard you, and now we lost you.
Maybe we'll wait for Shane to
The
come
neighborhood owners or their family members, or else we would be hit with liens or any sort of legal action they could take.
Wait, but can you back up? Because we lost you for about 2 minutes there.
Okay, wait, can you guys hear me? I'm sorry, I was driving.
Yeah.
Yep.
Okay, so we got a letter from the Seven Hills subdivision that said as of February 4th, 2026, all properties have to be occupied by the owners or their family members, or else, they're going to put liens or any sort of legal recourse they can take. So like, that's the exact verbiage in our letter we got.
You guys are in the same neighborhood, so. It's funny, there are several neighborhoods that are doing this, but you two happen to be in the exact same one.
Is it really the
Yeah,
exact same one?
Yeah.
Yep.
Oh,
Seven Hills.
Yep, I'm Seven Hills.
and where is that, by the way? I'm not familiar with it. Just
North
curious.
County, roughly 270 in Halls Ferry.
Okay.
Yeah.
So it's not St. Charles or something. It's North St. Louis County.
Correct.
Uh-huh. Yeah, well, any other people we should hear first? Suzanne?
Yeah, I have the same situation.
Okay,
Mine is in I think it's Hathaway Manor. It's out
okay.
near that same area, Hathaway Manor North. I've had the property for about 6 years, but just actually last week I got a letter that they're going through a vote now of trying to eliminate rentals. And if you have a tenant in there now, it's fine, but once it's time to renew, they don't want it to be a rental anymore.
So John, yours
Mhm.
hasn't passed yet. It's just going for a vote at the HOA at this point.
Right. And I sent in my letter voting no as soon as I got it.
Yeah.
Right. Okay,
And they want 2/3 of the majority to pass it.
Okay.
well, that's interesting too. I'll comment on that as well
Suzanne?
when we get there. Anyone else?
Yeah, this is Merle Schneider. I had a situation. I had a situation about 15 years ago, and I still own the property, but there was about 5 of us in a condo in Sherman Park, 5 investors, maybe more. And the HOA was trying to change it. I can't think of the attorney's name. Pretty prominent attorney in this area, used to represent Whitmore, I think, or Whitaker. But anyway, he stood up at one of the HOA meetings and said, you cannot change the use of our property. You can grandfather it, but when I bought it, if the rules were in effect, the attorney claimed that he could go to court, but you're better off if you don't, that you need to grandfather the 7 or so investors. I know what they were doing. They were putting a limit on how many there could be. So if there could only be 5, and if mine went vacant, I'd have to wait vacant until I became, somebody else's went vacant. But anyway, we blew them apart and haven't had a problem since. But it was contested just in the HOA meeting, and I guess they believe the attorney.
Mm-hmm.
Yeah, I just had the same situation with a condo that I have. Right now, I have my mom living there for several years. But they just passed it such that only so many units can be rented. And if you sell your unit, the new people that buy it cannot rent it.
And that's something that, from my perspective, it's the retroactive action, where you have so many of the folks who've bought it for the purpose of investment with, loans and obligations, and now you're retroactively changing the use of the property. That's I think a fairly significant issue. But Roger, why don't you jump in with what you've
Yeah.
found? We'll go back and forth.
No, that's going to be, you're already right there, Tom. That's going to be the fault line where it's not 100% clear, but that's where the borderline is going to be. I'll explain that to everybody else, but I think everybody who wants to chime in first. That was good, though, to hear from a few real cases. I appreciate that. But I guess I should jump in now.
Yeah.
Okay. Yes. Well, the general gist of it is, it starts out sounding more favorable than it's going to end up, unfortunately. Because if I start with a general rule, the general rule is that a homeowners association subdivision, they can be called, by the way, you've heard, those of you that have been doing this a while, they can be called bylaws, they can be called indentures, they can be called covenants. It doesn't matter. They're all the same thing. And But whatever you want to call them, the subdivision rules or bylaws or indentures, that's probably the most frequent term. They basically, the starting point in any court's analysis is that restrictions on the ability to freely sort of associate and disassociate yourself from property, free commerce in property is not favored. In other words, that encumbrances on the ability to buy and sell property are not favored. That doesn't mean they can't exist, but what that's a sort of signal to lawyers that you can argue a lot about it, which means you can run up your client's bill a lot about it. But basically, what it means is that any rule like that is going to be strictly, the legal language is, it's going to be strictly construed against the HOA. So if there's any ambiguity about what they're trying to prohibit, you're going to get it says, I guess I said it, that is what it means. Now, where does that come up? And there were a couple of key cases. I won't cite the cases except Tom and I can talk about them afterward because you guys don't care how we got here, but have been some cases on this. The most interesting thing about these two cases that are relatively recent, and therefore I expect will be definitely referred to by any court in St. Louis County. And they'll be binding. I shouldn't say it that way. Appellate courts, even though an appellate court might be the St. Louis County's appellate court, or it might be St. Louis County's court and then appealed from that. The point is, any appellate decision is binding on any part of the state, even though it only arose in a given county. That might be something that's not obvious to everybody here who's not a lawyer. But once you have a court decision, it certainly at the appellate level, it's actually directly binding on the whole state. At the trial level, meaning the first layer, the first decision, is not absolutely binding, but will be most likely followed by a different court in a different circuit or a different county, in other words. So we have, but I focused on St. Louis County. We have two very interesting decisions. One involved a subdivision indentures that said that there shall be no, said that the properties must be used for residential purposes and not business or commercial purposes. So the interesting thing here was that the trial court said, oh, you're out of luck. You can't rent your property. That's pretty clear to me. And the appellate court said, no, 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 no. The appellate court reversed the trial court and said, no, no, no. If you're renting it, what that means, you can rent it. You just have to rent it to people who are going to live in it as a residence. Right. So you didn't open a shoe repair shop in the building. You just moved people in who are going to live there, bona fide. They're going to live there. And so that became clear. That if it just makes that distinction, that's not going to stop rentals. And that was a certain actual court case. The other one that's really clear is, again, the same point. Again, where a business use was prohibited, but the indentures limited units to single family residential use. Again, in that case, the defendant was actually, I don't know if it was, I don't see the term Airbnb being used, but the term used in the court case was nightly rentals. So people could rent it on a one-night basis or more. And that too, even that was not, it's still, they're living, it's like a hotel. It's a residence, temporary, but it's a residence. And so again, that distinction is the same point. You can't open an ice cream shop, but you can move people in and out who are going to actually dwell there for the time being. And so that's so any subdivision that just makes that change. Oh, we're going to just say no commercial purposes. Well, if they intended that to stop rentals, they goofed, because that's not going to do it. And you're going to win. And if you get a letter like that, and I mean, by the way, I might as well jump to this now and throughout. Probably, Tom, we both should do this. Instead of just going on and on about the law, I should take a pause occasionally and say, okay, so what does that mean practically? And what that means practically is you get a letter like that, you got to bring us the letter, either Tom or me. I don't care. But you got to bring us the letter and get a hold of the subdivision indentures. And that can be a pain in the butt, because many times they've been amended multiple times and it's actually somewhat hard. Even the trustees don't always have the whole thing at their fingertips, but if they're going to prohibit you from doing something, they better you can get a little stern with them and say, you can't prohibit me if you don't have the whole set of indentures. So yeah,
I would say, as far as the indentures and if the bylaws have been filed, that's where having a relationship with somebody at a title company can come in handy.
Oh yeah.
Because then, hey, I'm in this subdivision. This is my address. Would you guys mind getting me a complete set of the indentures? I mean, it's what they do all day long. And so they're going to find it faster than Roger or me, do that. And I would say, again, as a practical matter, someone in the Facebook chat had mentioned that the subdivision had a vote and it didn't pass. And so that's the other thing that I would suggest is, for those subdivisions that say that they've passed it, I want to see the documents on that.
You want to see the minutes.
Yeah,
of the
where are the
meeting
minutes, where are
where it took
the
place.
votes? Because, if it calls for 66%, or 66 and 2/3, whatever the amount may be, did they provide everybody with the appropriate notice under the bylaws or the indentures? And how were the votes counted? Just because they send you a letter that says we've done this, and if they stonewall you on it, that to me raises a whole other issue, because you're a member of the association, you're paying fees, and you're entitled to those things, so that you can see, especially when it's affecting your ownership rights. If they're playing games with that, that's another red flag that just makes me wonder if they followed all the steps that they were supposed to follow.
Right. I mean, they definitely would be held, and a court, I would agree. And we do our shop does a little more litigation than Tom. A court would definitely that's part of strictly construing. That's that same term. They would, if you came in with good evidence that they didn't fully follow their own rules on this change, and there's all kinds of steps there, like what's a quorum? I mean, how many showed up? Was there a quorum? And then who counted the vote, and was it secure, or was it kind of loosey-goosey? For such an important right, where you're definitely depriving people of a clear, what would normally be a clear property right, the court's going to look to see that that they strictly followed it, that they gave the right notices. for the meeting, I mean, every step along the way, the notice to come to the meeting, was it very widespreadly, was it, did a lot of people never even see it? And what did they do? So you can definitely challenge it. The thing is, I'm aware it's from years of experience, Tom, and I'm sure you do have the same point to make. It's one thing to say you have a winning court case, and another to say, if I write a letter, it's going to work.
Right. Oh, absolutely.
So some of these situations, I realize that when I'm saying, when the net of what I'm saying adds up to, well, you'd have a winning court case. Yeah, but that's not so great. I mean, that costs a lot of time and money.
Yeah.
And I understand that. So that's where we would need, again, either Tom or I would need to read the indentures carefully, look at the procedures as much as you can find out about how they did them. And the more you can get about that, the better. And you bring all that to us. And I can also sort of spot the distinction between something where I write a letter and any lawyer they bring it to is going to agree with me and it's going to be over soon, versus I write a letter and a lawyer is going to write me back and saying essentially, well, we'll see you in court because this is not that clear cut. So I'm trying to make that distinction to everybody here also. The place where you're in that not so favorable land of you might win, but you might not, and you might have to bring it to court. To me, it's a borderline where what if they followed, and this is just an interesting question, Tom, for us as lawyers, but interesting is never good for the client.
Right.
Is what if they followed all the rules very strictly? Let's just assume they did it all right. But their bylaws only call for 50% show up to be, that's a quorum. And once a quorum's there, a simple majority can pass anything. So you could have, if there's 50 houses in the subdivision, you could have 25 show up. You could have 13 in favor and 12 against. And now you've got 13 houses out of 50 that just took away your right to rent in the subdivision. But do you think a court that might be challengeable with such an important right that, yeah, your bylaws don't require a supermajority, but we're not comfortable, we, the court, are not comfortable with that because this is such a fundamental right of such a fundamental property right that what we would, but might allow is if 66 and 2/3 of the actual homes not only showed up but voted in favor of this restriction, okay, now that would have that would be almost unattackable, I would say, but you don't usually have that.
Yeah.
I mean, let's say the obvious again for people, right? It's obvious to everybody here, lawyer or not, that if 100% of the homes minus you, the one guy who's renting, or guy or gal, the one owner who's renting, if everybody else votes, if you get basically close 100%, except for the one person who doesn't want it, you're going to lose. I mean, they can do it because it's effectively 100% or close. Yeah. And one outlier is not going to stop it. But it's the question of, well, how much less than 100% is enough? That is something you could probably mount a court case on. The question is, do you want to spend that time? And if they've done it very carefully and done it right, but the most important thing from our point of view is, and the wording is extremely clear, that it's not just, okay, generally prohibiting commercial use, only residential. No, that you blew it. If you're the homeowners association, you blew it because you're renting it for residential purposes. And the courts have been so clear about that. I don't think they're going to flip-flop on that. They actually, you should know they can, but that's much rarer and pretty unlikely. So, and I like, who was it who brought up the idea that it's one subdivision, and I sort of, some lawyer must have advised them of this because it makes sense to me as a lawyer, which is any people who are renting now already at the time we adopt this clause, we're not you can keep renting, but as soon as you don't rent it, it goes off the list. In other words, it's grandfathered in until you don't use it that way, and then it's gone.
Yeah, I have questions about change the retroactive change
Right.
because Corey, I know you brought up the letter and this idea that we're going to set an arbitrary date and we're going to
Mm-hmm.
change the terms of the lease that you have. I don't know that they necessarily have that authority. If you want to change it prospectively, and I think someone mentioned this earlier, if you want to change this going forward, again, if I change the use, if I no longer use it for rentals, that changes it, or if I sell it, then the new person buys it knowing this restriction is in place, then that's one thing versus I've got this investment strategy and I've committed myself financially for this, and now you're changing the rules on me. Now, what Roger said is accurate that challenging these things can end up in thousands and thousands of dollars of attorney's fees. If you can band together with a couple of people and help defray that may be one way to go. I think the other thing that I would mention is use to the extent you might know other owners, you know, talk with them about it. See if you can find out what their concerns are and how you can address those as a practical matter. And by all means, attend or have somebody attend every meeting where this is discussed so you know what's going on. Because leaving it to other people or for the HOA to report to you,
Mm-hmm.
you never know how that's going to be construed or what actually happened when they were talking about this.
The other thing is, I can see lobbying. It's occurred to me, I can see lobbying for making a distinction between overnight rentals or very short-term rentals versus someone who's, in other words, a restriction that says rentals have to be for a 1 year lease or longer, so that it's a different kind. Yes, it's a rental, but it's not a turnover. I could see a neighborhood not wanting constantly a new face in there every short amount of time. But I think that in if you're faced with if as an investor you're faced with it's looking like the majority of homeowners are going to vote for this, maybe one could lobby for, okay, well, we're not going to, okay, we can't do an Airbnb in here anymore if we ever were even thinking of it. But making the case that a long-term rentals like for a year or more should still be allowed because that's clearly, it doesn't change the residential character. And sometimes if people have children, especially, and they're going to go to school in the local school district,
Right.
that's likely to be a tenant that's going to be there for years. And not always, not guaranteed, but that one could lobby and try to build a consensus for that. But but you might have to work at that and try to get that, try to do that because if they word it right and if they follow their own procedures very, very thoroughly and carefully to the point where it's not easily attacked how they did it, they probably can do it. Even, I mean, it would be a bit of a toss up in my mind, even the retroactive case.
Yeah. Yeah.
They would. That's the closest call. I mean, that's the one that's that's the one that's on the fence as to whether they could, but certainly one that, like Tom said, says, okay, but if you sell the house to a new buyer, they can't do it. And if you, um, the close call is going to be, okay, we're not going to abrogate, we're not going to negate your existing, if you have an existing lease, we're not going to, no, we're not going to throw, we're not even going to try to throw them on the street. But as soon as that lease is over, the homeowners association, prohibit you from entering into a new lease? That's right. That's what I mean by that's going to be right on that border. The answer is you can argue it both ways, unfortunately.
Yeah. There are two things. Corey has a question, and John Brown Rogers said he cares about the cases. So if you can maybe put him in the chat, or after we get Corey's question, tell him what the cases are. He's interested in that.
Oh, okay. Well, do you want to keep talking a minute while I
Yeah,
think
Corey,
about
what was your question?
Yeah, so my question, so mine is it goes a little bit deeper as well than just the changing the use. I think like 8 months ago, I took out a blanket loan that wrapped this property up with two other properties. And this is actually the main securing property because I had the most equity in it. So having to sell and remove this property would be very detrimental to that entire loan. I don't know if you could talk anything, if that weighs into anything, or, if it's still just what they say, and if they did everything appropriately. But I mean, that's my biggest concern with having to, essentially untenant and sell the property is it's going to have a ripple effect throughout my entire rental portfolio.
Right. Yeah. I mean, that's where for me, I know that uh, there's an argument. I don't know how good it is, but there's an argument that these HOAs are created by the law, and and that as such, they're using they're impairing property rights. And so, my argument is that by impairing the property rights, and again doing it retroactively, that it amounts to an unconstitutional taking, both under the Missouri Constitution and the US Constitution. Now, whether that would fly or not, I don't know. But for your case, Corey, that's the thing, is that they're making this change after you have set something up financially, and it's damaging. And that's going to be damaging to any number of people who are in this situation, that this is your business, and you're changing the rules in the middle of the game. But the difficulty with that is that in order to challenge it, it it could end up being litigation, which ends up costing you thousands of dollars. And so, that then becomes kind of a cost benefit analysis for you. Is, yeah, I can make this argument. Um and my favorite thing in litigation, when people ask me, can I win? That I'm optimistic, or at least feel decent about it, if I tell you I'd rather be in your position than theirs. And that's about as much as I can. You might be at 50.1%. And that's a risk. Nobody wants to spend thousands of dollars with an attorney, and not be sure of what the outcome is. So I think that there are arguments to be made. The question is what kind of appetite the different subdivisions may have for potential litigation. If they see that an attorney's involved, Roger mentioned it earlier, the lawyer for the HOA may say, yeah, we'll see you in court. Um, and see what happens. Or they may say, well, we don't really want to go after, or do an assessment against our other owners to have to pay for the lawyer.
Mhm.
Um, that's a you just never know what kind of appetite they may have for litigation.
I feel like,
Yeah,
Tom and
you can,
Roger, if you guys don't mind, I feel like I'm gonna kind of summarize what I've been hearing, and then we do have a couple more questions in the chat.
sure.
But to me, it sounds like be proactive at HOA meetings if you hear any whispers about them trying to, ban rentals, be involved, talk to people, vote no, all of that. But if you happen to get that letter, then that says, we are banning rentals, here's what you need to do. It sounds like you should see if there's any other investors in that neighborhood. Maybe all come together to meet with one of you,
Yeah.
just to kind of help that burden, and then see what you guys are able to gather to see if, you know, you can try to stop it, or if looks like it's going to have to go through trial or litigation. But it sounds like there's not a clear, like, they can't do it or they can't do it. It's definitely in the gray, and not a lot of case law on it. Is that fair assessment?
It's fair to say, I mean, again, it's black and white if they just said no commercial use, only residential use, which
Yeah,
sounds like they win, but they actually don't,
yeah.
if that's
That's
all it
where
says.
your cases come into play, Roger.
But
It
when
depends
they
They
on
have
make
to,
it, but when they make it more specific,
but when they make it
that's
more
when
specific, then
it
yeah,
it it becomes a bit closer. And that's where how they went through their process really makes a difference.
yeah. Okay. Are we, any other questions specifically on this before we change topics to some of the other ones in the chat?
by the
Okay.
way, Suzanne, I'm gonna put, um, who was it who asked me?
John Brown.
No, someone asked me to put the actual case site in the chat, which,
Yep, it was him. Yep, you can put him in the chat.
yeah,
He's
so
he's an attorney.
An attorney, yeah.
oh,
That's why he wants the.
got it.
He said short
Yeah.
short citations are fine.
Yeah, sure. Yeah, we don't need the Supreme Court citation, you know.
No, that's fine. I'll just put it the way I would normally do it,
Thank you. Thank you.
Okay, so I'm just gonna go through the list. So one is from Brian, who has some short-term rentals in Innsbruck. It says they've now added an additional nightly fee only for short-term rental operators, along with a business permit. Any thoughts on that?
I do think it would depend on what the indentures and the bylaws say. I think that as a concept, the fee doesn't strike me as problematic, mainly because it's something that you see from hotels all the time. We have the convention center tax, we have the tourism board tax, and so I look at that and go, that can be, even though it's a pain, that can be a pass through to your potential short-term renter. But whether or not that's permitted really depends on what the bylaws the bylaws or indentures say at Innsbruck. And again, I'd look at what was the procedure, how was it enacted, and, you know, try and work it backwards from there.
And then Brian had one other question, and Brian, Brian Housley, you might have to, you said, what about the city changing property tax collection from residential to commercial? Do you mean, what city are you referring to?
What's the
St. Louis.
distinction, I guess?
St. Louis City, changing property tax collection, and this is for short-term rentals, for changing that tax from residential, which is more favorable, to commercial, which is higher tax rate.
I guess what I think about is if they're equating that to a a hotel, then that might fit. I don't think the the classification would work if they were trying to say that a residential property was commercial. But I think their argument would be, well, this is, hotels are commercial, commercial properties, and you're as a short-term rental, you're doing the same thing as a hotel. And so we're now classifying you in the same way as a hotel. I don't know whether that would stand up or not, but there's a certain logic to it that might support what they're doing.
I mean, in at least one of the cases, there was this city hall got involved, and the first approach of the people, and that was the case where they were actually already doing just overnight rentals. I think it was down, frankly, by Lake of the Ozarks, and that could explain why there was a market for that, even this was in 2006. And so I don't even know if the term Airbnbs was being used yet, but they went to the people wanting to rent it overnight first went to City Hall to get a variance, because that was one way they were advised to do it. But it turned out that because of the way the indentures were worded, they won without that. They were denied the variance. But then the court, the trial court, then the court, the court decided in their favor, meaning that this is still, quote, residential, because people are living there. And so they made that distinction. So, but yeah, there's ambiguity about who's even got jurisdiction over these decisions. I mean, in the sense that, does local city hall in the location where the property is have something to say about it, either city or county? Unfortunately, there isn't an absolutely black and white answer to any of these questions, but we've sort of outlined the general principles, kind of like I'm trying to give a flavor of where the clear borders exist and where the borders are a little bit gray.
Sounds like there's a lot of gray.
Unfortunately.
All right, and then Chris had another question in here that he put. What about the city of Delwood? They have a 30% cap on rentals per block, but most are at 50% rentals right now. They also completely banned short-term rentals in residential zones, done by ordinance in 2021. Does that need to be challenged in court? I feel like Berkeley had something similar that they had done a while back.
Where was this? I was sort of writing my citations out, so now I'm done.
It's in Delwood.
Yeah, someone else. I have a case from someone about something else in Delwood. or they're acting, but this is, I guess, I'm trying to think, I guess it's not really related, but they're acting very bizarre. With another client of mine, with a client of mine, but it's not exactly on this issue, but it's peculiar.
The thing I wonder about with that is if there's a cap, but they're not enforcing it. Is there an issue as far as the application, the application of their ordinances if they're not applying them across the board? That at least, just kind of thinking about it off the top of my head, that certainly seems arbitrary. As far as the ban on short-term rentals is concerned, if they've done it through the zoning, their police power, the zoning power, that's something that may stand up, because they may have that authority to be able to say we only do short-term rentals in these particular zones.
They might have to justify it by some kind of logic that there's, some reason why it's bad for the public health and safety, to allow this here. It may seem kind of made up to us when they tell us these things, but if they can just back it up with just some kind of reasoning, it might usually be enough. I think a general point I'd like to make is that when I first, and this is 10 years ago or more, when I first got a chance to litigate against an HOA, I read all these things about how the decisions can't be arbitrary and capricious, and how, they have to follow the rules strictly, and how changes that take rights away from property owners are, read strictly against the homeowner association. Have to be, it all sounded reasonably optimistic that I was going to get somewhere with, because my client was suing the HOA for whatever it was. It's turned out in practice, having now litigated against a fair number of HOAs, that it's not as good as it sounds. So unless it's very black and white, like I said, that one rule we have, which is clear, that just saying no commercial use is not going to do it. You got two very clear cases. That's why reading what they've written and checking into the grandfathering provisions they've either allowed for or have not. But I would have to warn any investor who came to me to go ahead and sue that it's like fighting City Hall a little bit. The reality is that courts pay a lot of deference to what the HOA, not only anything reasonable, but even in some cases, anything even unreasonable that they've done, but they've done supposedly in accordance with the procedures that are given in the indentures. The issue becomes that the courts, I've also seen, I haven't seen it in writing, but I've seen it in court, which is that they also recognize that most HOAs are just a bunch of volunteers, that they are also just homeowners in the subdivision, that they don't have deep pockets to litigate endlessly without assessing everybody, and even that's not going to be popular. So knowing that, there tends to be, unfortunately for investors, there tends to be some deference to, at least initially, to certainly anything reasonable sounding that the HOA does. And even sometimes things that are unreasonable sounding, but which for one reason or another, they've adopted according to their so-called procedures. So I would not want to tell any investor that it's an easy case to win.
Yeah, I would say, if somebody is talking to you about litigation, and they're telling you it's easy, I would be running away.
Yes.
Because you just never know what can happen with litigation. It's just you're putting your fate in the hands of a judge or 12 ordinary people, depending on what the circumstances are, and that's a risk. Yeah, John.
I wanted to share a little personal experience to put a more practical number on this. I've been fighting an HOA. I won't go into the details, but about a short-term rental. It's been going on for 3 years now. I have another attorney who's litigating it for me. I've spent $30,000
Mm-hmm.
Yeah.
and we
Yeah.
still haven't been resolved. And the HOA is in the complete wrong here. I've spent $30,000. They've spent close to 50, and we still haven't resolved it. They're like you say, they're playing with house money. So, the HOA members don't care, or the HOA board members, it doesn't hurt them personally to
And
continue.
they might even have insurance.
Yeah.
Sometimes they do
So
also.
these guys are right. The litigation part is not fun. It's cost me more than I'd like to admit to you all.
Yeah,
One
and
other
then
point.
there's the stress, there's the stress of
Yeah,
dealing
absolutely.
with a lawsuit and having to respond to the different deadlines that the court comes up with, taking depositions. It's not a small thing. And so, when I probably talk 90% of the people that call me out of filing lawsuits, because of exactly what John said. And what Roger's talked
Well,
about.
and those numbers that John said are completely realistic. Don't think
Yeah.
you're gonna, come in under that necessarily. And one other point that always comes up, so I'll bring it up now, which is someone like John, if he was coming into my office at the beginning, would always ask me, of course, and of course, if I win, I can collect my attorney's fees, right?
Right.
From the other side. And no, not under so-called American rule. Only if they do something just incredibly egregious, then maybe. And that's during the course of the litigation. But just simply for taking their stand on what they believe is the correct interpretation of the law and having a lawyer argue on their side for that, no, the court's going to say each side bears their own. I mean, you don't have to pay their attorney's fees, but you've done nothing wrong either. But you're not going to get your attorney, even if you win, you're not going to get your attorney's fees on top of any damages that you could prove. So that's another deterrent for about bringing these, unfortunately. But that I might as well say it now.
Yep. Yep. Absolutely.
Well, we are quickly approaching 1 o'clock, so I'm going to get us wrapped up. But I just want to thank you guys both, Tom and Roger, for getting on today and sharing all your knowledge in the legal space. I feel like I've learned the law just continues to be gray, but I feel like I'm appreciative for this group to all bounce ideas and, see what everyone's seeing. With everything that's going on in the real estate world.
Suzanne,
If it
can I
wasn't
make
great,
a
we'd be
quick
replaced by
comment, Suzanne?
ChatGPT.
Yes, it
Yeah,
sounds
Merle,
like
what-
ChatGPT might not replace attorneys, at least right now with all this gray.
So Merle said he had one quick comment before we leave.
Oh,
Yeah, just going back to when both of the attorneys talked about when the HOA is starting to have discussions and make sure you attend the meetings. Not only that, bring a troop of attorneys with you, because after it gets voted on, it's real tough. But before, you scare the hell out of them, and HOAs are scared to death for a lawsuit. And so that's when you bring the artillery, even if you have to bring both Tom and Roger and a few other ones on their back, they will back off.
Well, and we'll bring the picture that Suzanne posted to or Rachel posted to Facebook, beating up the HOAs.
Well, that's what we did. We had 7 or 8 rental landlords, and we brought the attorneys. And that's at the very least, you should get grandfathered, on your existing unit.
Yeah.
This business of changing the use is a weak argument.
Yeah, well, the more you, right, I agree, the change, the strongest one is no one's gonna make you, I'd say you're definitely gonna win that you don't have to do anything about your existing leases. The only point where they could even try is after your leases, whatever lease it is you've got now is over, can you lease it again? And as long as, but you're saying, Merle, and I agree, you have a fighting chance to say, no, 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 we bought this property with the understanding that there was no prohibition, and you're taking away a significant right. And we're gonna, and that can't, that, and Tom alluded to this, but one argument, if I were on that side, I would be arguing that that's what's called constitutionally called a taking, meaning that if you're really gonna do that, the government has to do it, and it has to be, and I have to be compensated for your taking part of my land rights. So that could be part of that would be part of the artillery that you would bring, that you guys are going to have to compensate us for the taking away this right. We have, as someone else mentioned, we have investment, we have, promissory notes and deeds of trust and similar arrangements that were included the concept that these were going to be income properties. And so all of that could be brought to bear on it. But that's exactly where the fault line, that's the battle line right there. I can't promise that it's automatically a win, but it's a conceivable win right there, but they could then prohibit that anyone else who hasn't been renting them up till now all bets are off for the future, except if they try to do that, they definitely would succeed. In other words, to say no more, only you guys who've been using it that way for years, okay, we're not going to try to take that away. They definitely could do that. So if you're going in now to buy a new, once and then from then on, any new property you bought in there, you definitely couldn't rent it if they did it properly. So but right there is where a very expensive court case is waiting for someone right there.
Awesome.
Marley, we can't hear you.
Well, we're going to actually, it is 1 o'clock, so we
Oh.
are actually going to wrap up. I want to make sure we respect everyone's time. I appreciate everyone hopping on. Thank you so much, Tom and Roger, for joining us today. This was super helpful. I hope everyone got something out of it for themselves. I also want to thank some of our vendors and give a quick shout out. Nikki and Kathy are doing a property walk next week, September 3rd. They're going to do it in South City this month. So if anyone is wanting to get some understanding on what to look for in especially city houses for rehab, but also design stuff, definitely check that out. It's an all-day event. It's super affordable. I did it last month and had a ton of fun, and so you always learn something when you're walking houses. So, and with Nikki doing design, I think it's just going to be even better. So anyway, that's next week. If you guys need any other vendors, be sure to check out the Buyers Club vendor team. But otherwise, we will see you all next week. We got a case study with Matt Cresco talking about his 4-family. So should be fun.
Very good. Thanks for inviting us.
Thanks,
Yeah,
Tom.
thanks everybody.
Thanks, Roger.
Bye-bye.
Bye.
Thank
Right.
you.